hope all of you are letting your soul shine on this beautiful day. How are you, Shamash? Welcome.
Hello, hello. Good to be here.
Are you
How's
here?
everybody doing? How are you, Sam?
Probably not. Let me send this one text I forgot.
What is it? All is good?
Invite people. All right. Shamash, are you here?
Yeah, I've been speaking. Can you hear me? Hello?
Do you guys hear Shamash, or is it just me that I can't hear?
I can hear you.
Anybody? Oh, okay. All right. Very good. So today we're going to finish the conversation on trade secrets. Next week we're going to start the conversation on patents. And so as the final installment of Shamash.
Hey, you can't hear me yet?
Nope.
Ah,
Still
shit.
not yet. So anyway, as the final installment, we're basically going to go and look at the instrument that creates or allows us to protect our trade secrets. And that instrument is the non-disclosure agreement or the confidential disclosure agreement. So the slides for today's session are, the link is posted to the top, Anatomy of an NDA. And if you'd like to follow along with me, the slide numbers refer to the order of the slides in the presentation. All right. So far we've been talking about, no, Shamash, we could never hear you. Do you want me to wait until we can hear you? Okay. Okay, sounds good. All right. So far we've been talking about all of these trade secrets and how we should keep them a secret and never disclose them to anybody and this and that and the other thing. But the thing is, that is not the reality of the business environment. The reality of the business environment is that we're looking for deals, we're looking for cooperations, we're looking for mergers, right? I mean, companies have to deal with each other all the time. And in order to kind of know whether they want to do something or not, they need to be able to evaluate the project, evaluate the merger target, etc. And so information needs to be exchanged, yet at the same time not lose its trade secret status. So how do we do that? And in slide 2, we basically create a zone of confidentiality, meaning that we draw a boundary and we say anything inside of this boundary is considered confidential, and so any exchanges within the boundary are considered confidential exchanges, and anything outside of that boundary is going to be non-confidential exchanges. So internally, we do this through employment contracts. So every time you get hired by a company, as part of your employment contract, you have these duties of non-disclosure of any of the confidential information, and they disclose they tell you how to decide if something is confidential, something is not confidential, etc. So internally we can hold people accountable through the employment contract. Externally, we we sign a contract with the recipient of the information that would basically gives them a contractual duty not to disclose the information to third parties. We call this contract a non-disclosure agreement or a confidential disclosure agreement, NDA or CDA. There is, aside from their names, there is no difference between them. So I like to ask people to, if you'd like to, just come up and ask questions so we can get a conversation going in addition to just me talking. All right, so on slide 3, we have two types of NDAs, one way or mutual. One way means that I'm talking, you're listening, you're not giving me any information about you, you're only getting information about me. Mutual means that we're both exchanging confidential information, and so the duty of keeping something secret rests on both of us. In the top one, the guy on the right has a duty of keeping the information secret, but the guy on the left doesn't, because the guy on the right isn't telling him any secrets. So these are the two types of NDAs, and usually when you're dealing with a large company and you're a small company, they would ask that you sign a one-way agreement, because they don't want to be responsible for any information that they give you. They just say, yes, whatever you're telling us, we're keeping it secret. But that way, they also tell you that they're not disclosing any confidential information to you. But in a mutual way, that's usually mutual non-disclosure agreement. That usually happens when companies are actually going through the deal, because now in the deal, we need to exchange information. Both parties need to exchange information. Hi, Horrible. Welcome to the stage.
Assalamu alaikum, brother.
Okay, so now on slide 4, once we've decided how this deal is going to go forward and how the information would be shared, we're going to draft and sign an NDA. An NDA has these 5 parts to it. And actually, I should say it's these 5 parts are not unique to an NDA. These 5 parts are for any contract, any agreement that you sign. You first identify the parties, you decide what the effective date is. Then you have certain recitals, certain sentences that set out the background for this agreement. Then you have the meat of the agreement. This is the thing that in some contracts goes on for page after page after page after page. In an NDA, it's usually no more than 2 pages long. Then you have boilerplates. Those are clauses that go into every contract because they protect certain general aspects of the deal, and then it's the signature part. So the first is the parties. Basically, we have to define who is agreeing with who are the 2 parties that are involved in this agreement. So the confidentiality agreement, hereinafter referred to as agreement, effective as of the effective date, by and between ABC, having an address of, hereinafter ABC, and XYZ LLC, having an address of, hereinafter XYZ. So basically, we have identified the two parties to this contract. And we have given an effective date. So there are two different ways of introducing the effective date. You can actually give it a date. The first drafts of the agreement will have as of September blank of 2025 effective date. So when you go ahead and sign the agreement, you can fill that in. The second one is the one I like the most, and that's the one I put into my agreements, is as of the date of the last signature here too. So the date that the last person signs something is going to be the effective date. But these are not the only parties, right? The parties include other people. So each of A, B, C, and XYZ is referred to as a party, collectively referred to as the parties. But the term party includes each of their respective employers, parent entities, affiliates, or subsidiaries. And so employer is as defined by Department of Labor. Parent is someone who has a controlling share of the party. Subsidiary is one in which the party has a controlling share. Affiliate is they have the same parent, and then you define whoever is talking is the disclosing party, whoever is listening is the receiving party. So we basically...
Sam, can you hear us?
Sorry.
Sam, can you hear us?
Oh, I can't hear you.
Yeah, because this is actually a good time for me to ask my question,
Hold on a second.
which I've been...
troubleshooting. I can't figure out why. I can't. So let me do this. Is this better? Can you guys hear me now?
Yeah, we can hear you. Can you hear us?
And let's see if I can hear you.
No.
Sam.
Nope, I still can't hear you.
So if I yell, it
Shamash,
doesn't
I'm
work
gonna
better?
leave and then come back.
Okay. Oh boy.
Yeah, because my real world example is exactly this. Can you hear me, Shamash?
Yeah, I can hear you. I think he has a problem on his end.
Yeah. But the thing is, with institutions, when you do a master's degree or any dissertation backed program.
All right.
Can you hear us? Can you hear us?
Yes, now I can hear you.
Great, cool.
Okay,
Welcome.
Sam.
So
I have a
okay.
question that goes to this right now, actually. So, how strong are patents when they're patent under an institution rather than a particular individual? So, basically, my master's degree, I wrote a paper that my advisor took that paper, made a patent from it, and the patent is under the institution of University of Toronto, has nothing to do with me. I get zero residual. I get zero. I get zero income whatsoever. It has nothing to do with me. It's a hydrogen fuel cell technology that my
Yeah,
dissertation was
so
based
let's before we get too deep into that, let's postpone the conversation on this when we're talking about patents.
on. Okay, okay.
We're now talking about trade
Indeed.
secrets. Yeah,
Hmm.
and so the short answer to your question is the institution has all the rights to the patent, and you don't have any rights to the patent.
Yeah,
That's the short
I figured.
answer, but we'll discuss that when we get to the patent section and inventorship and ownership and all of that stuff. It's a pretty complicated calculation.
Yeah, and Sam, I've talked to many lawyers, right? Patent lawyers in particular, they say the exact same thing. I just think that's BS. I think that's complete BS. Like it's not fair, but okay.
Well, you should express your disagreement to state legislatures who write the business and labor laws for
Yeah.
the state.
Yeah.
Yeah, all we're doing is following the law. We're not making the law. So you should express your disgruntlement to those who make the laws, not those who are just following it. Anyway, so after were there any other questions? Anything else that I missed while I was
Well, I asked you how
rambling?
are you in the beginning. I'm not sure if that counts.
I'm doing really well. Thank you very much. Uh, I realized that this morning, I mean, so yesterday, the US, we had a holiday, it was Labor Day. And so this morning I missed an appointment because I thought it was Monday. So I missed the first.
Wow, that's
Yeah.
that's cool.
Yeah. All right. So moving right along to slide 7. This is the recitals. This is or whereas clauses. And you get a different answer talking to different attorneys as to whether you even should have recitals or shouldn't have recitals. Uh, it basically becomes to the personal uh, style of the attorney who's writing it. They're not necessary. If you don't have them, your agreement is not invalid. It's still valid. I like them because what it does, it basically puts the agreement into proper perspective and kind of say, what is it that we're doing here? First it was, who am I? And now it is, what am I doing here?
So
So we,
what's a recital again? Just to be clear.
so it basically you recite a set of recitals in a legal document is you're reciting a set of facts that are not in dispute. Okay, that basically in a normal like legal document when you have recitals, it means that both parties agree to these.
So
In
it's like the base starting point of the
Yes,
narrative. Okay.
yes. In a contract, recitals set about the background for the deal. So it says the parties possess business and other information that is confidential, and each party uh, will be given access to certain information by the other party for the purpose of exploring the feasibility of potential business opportunities with each other. Right, this is written really broadly. That second whereas clause, it could be because it defines what the stated purpose is. So you can tailor this agreement to have a very, very narrow stated purpose. We'll see how that will affect the use of the information later on. And then the parties have entered this agreement in order to assure the confidentiality of such shared information. So basically, we now know what this agreement is, right? this agreement is that each party has confidential information that's good for business and they want to share that. So they came together, signed this agreement in order to do that. So now, therefore, in view of the mutual promises and other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, the parties here to agree as follows. So that word consideration is highlighted because unless you've gone to law school or you've been dealing with a lot of contracts, the word consideration doesn't mean in this context what it means normally. So what is consideration? Slide 8, I have put down Black's Law's definition. Black's Law Dictionary is the authoritative dictionary for legal terms in American law. So what is a consideration? The inducement to a contract, the cause, motive, price, impelling influence, which induces a contracting party to enter it, the reason or material cause of contract, some right, interest, profit, or benefit occurring to one party, or some forbearance, detriment, loss, or responsibility given, suffered, or undertaken by the other. So what does all that legalese mean? Consideration means the benefit that the contract gives you. So the two sides that enter into a contract, both sides have to get a benefit from that contract. That benefit could be financial. It could be that you built a deck for me. It could be that you allowed me to enter the airplane and fly to San Diego, right? So the purchase of an airline ticket is a contract for the sale of a ticket. The airline benefits because they get my money. I benefit because they take me to San Diego. So we both have consideration in this contract. Now, if one party uh, doesn't have consideration, meaning that one party doesn't benefit from the contract, then we say the contract is invalid for failure of consideration. So if I give money to the airline, but they don't take me to San Diego, then the contract of sales has failed is invalid now because of failure of consideration, and the airline has to give my money back because the contract was invalid. So what we say in a non-disclosure agreement, we say mutual promises and other good and valuable consideration. So a promise can be a consideration, can be a benefit. I promise to keep your information secret if you promise to give me your confidential information. And so that's a perfectly fine contract as far as consideration is concerned. And other good and valuable consideration, here you say the receipt and sufficiency of which is hereby acknowledged. So basically, because you have signed this, you cannot in a couple of years go to the court and tell the court that, hey, court, why don't you hold this contract invalid because there was no consideration, as a failure of consideration. The court says, go away. You have signed here that you have received sufficient consideration. And so because you have acknowledged that, you now can't attack the contract for failure of consideration. Any questions on this? All right. So the next statement tells us whether this is a one-way or mutual non-disclosure agreement. So slide 9, in a one-way non-disclosure, it says ABC at its sole discretion will provide information to XYZ. XYZ consents that at no point during exchanges pursuant to this agreement does XYZ disclose information that is confidential. So that's a one way from ABC to XYZ. And now XYZ can't come back and say, hey, the thing that we told you, it was a mistake. It's actually confidential information. You're like, too bad, too sad. You acknowledged in writing that none of the information is confidential. What is mutual? ABC at its sole discretion will provide information to XYZ, and XYZ at its sole discretion will provide information to ABC. So your NDA will have one of these clauses, not both. If it has both clauses, then there's really good argument for invalidity of that agreement because it's not clear. So it will have either a one-way or mutual designation. And I also should say that you may not find verbatim or in the same order as I'm presenting here the information in any NDA that you may have been a party to, because again, where you put these clauses, how you word these clauses, it's very stylistic. As long as you are putting something in there that designates this as a mutual or one way, not by saying that it's mutual or one way. That doesn't mean anything. You have to define, like I have done here, one way and mutual. And so different attorneys use different sentences, different words to do this, but the end result of all of them is that they work. So basically, marked confidential, page 10. So what is this confidential information that that we shouldn't disclose, right? So it's marked at the time of disclosure to indicate it is confidential. So any document that you exchange during these negotiations and they're marked confidential, then they should be treated as confidential. Disclosed by them, so indicated orally by the disclosing party at the time of disclosure, or within 30 days identified as confidential. So if the paper is not confidential, as you're handing them over, you say, hey, by the way, all the stuff that I'm giving you now is confidential, that works. Or you call them back next week and say, oh, guys, that folder that we gave you access to, that is confidential information. And then the last one is that the receiving party should have known by the nature of the information and or its transmittal that the information is confidential. So if we're having negotiations and I open up my AR ledgers for you to see the profitability, you should know by the nature of this information that this is confidential. Companies' AR ledgers are not on the internet, are not publicly available. So you should have known. So we go to slide 11. Remember last time we talked about mens rea, that you have to have you have to have sufficient state of mind for you to be found liable for something. So here the mens rea for finding a breach of this contract is you knew or you should have known that the information you're disclosing to a third party is confidential information of the disclosing party. So note, we don't talk about trade secrets. We don't say you should keep their trade secret confidential. We just say you need to keep their confidential information confidential. Why is it that we don't say trade secrets? And that's because trade secrets are a subcategory of confidential information, right? A trade secret is a confidential information that grants you an economic advantage because you know it and other people don't know, and is subject to all those reasonable efforts. So I am not going to here identify which one of the confidential information I'm giving you has that extra quality of being a trade secret. I'm just going to treat all confidential information as if they're the Coke formula. And then later on, if something is breached, something is disclosed, then we have the fight over, hey, was this just a breach of the NDA or was it a misappropriation of trade secrets on top of the breach of the NDA? So then we go to slide 12. We've been talking about information. So in a contract, any word that is not at the beginning of sentence and is not a proper name, but is capitalized, it means that it is defined somewhere in the contract. I like to have in big agreements that I write, I like to start out with a section of definitions. Section 1 of the contract is always definitions. And it's actually that, how you define these terms, that is most important in granting of the rights under the contract. So this is such a small agreement, 2 pages long, that we don't need to do that. But information throughout the contract has been spelled with capital I, meaning that it needs to get defined. And so first we defined it as information is confidential, right? And how do we know it's confidential? It's marked, or we tell you orally, or you should have known it was confidential. Okay, but now there are exclusions to what is confidential information. One is that at the time of disclosure, it was in the public domain through no fault of the parties. So, meaning what? Meaning that it wasn't confidential. It was already in the public domain. Information that a party can demonstrate by clear and convincing written evidence was in the possession of the party prior to disclosure. So I've been working on the same stuff as you have. We want to see if a merger between us would be good. We exchange information. I say no, the merger is not to my benefit. We walk away. I bring my product into the market. You say, hey, this is the same product we talked about. You're disclosing my information. I say no. Uh, Before we started talking to you, I already had the plans for this product, and here are uh, all the specs that I had, and they're all date stamped, so we know that. So this is a clear and convincing evidence that's a standard of proof. You have preponderance of evidence is the lowest one, then clear and convincing is above that. then beyond reasonable doubt is above that. So this is kind of an intermediate level of evidentiary requirement that we have to provide. So that is a signal to the judge and the lawyers as to what they need to prove that point. The information that subsequently becomes part of the public domain through no fault of either party. So if somebody else reverse engineers this and discloses it, or Julian Assange hacks into your computer and then discloses it, well, it wasn't our fault, but it does become part of the public domain. Well, it's not confidential anymore. And the information that becomes known to either party afterwards, and information that is required to be disclosed pursuant to law or government regulation, as described in more detail below. So Section E is basically saying if I'm getting sued by a third party, and in order to defend myself, I have to use this confidential information to defend myself, I'm allowed to disclose that. But then there are different mechanisms by way of which this gets disclosed. Usually in these cases, if it's a really important trade secret case, the court uh, uh, basically assigns a special master to the case. The special master will receive the confidential information from both sides and then will make a decision which one of those needs to be disclosed, which one of them does not need to be disclosed, and then will provide that documents that could be disclosed under seal to the judge, and then the judge makes the seal official and under seal discloses it to the attorneys. The attorneys, when it's disclosed under seal, cannot disclose that to their clients. Only the attorney will know and will basically now tries to put together a counter argument based on that evidence without referring to that evidence. Yes, this is extremely difficult to do. It takes a lot of dancing around the issues so as things don't get disclosed. And there are times that it has to get disclosed, then the court will go into a secret session, or the judge will hold the evidentiary meeting in chambers so the jury doesn't hear the confidential information. So there are a lot of uh, avenues available to disclose confidential information for regulatory reasons or lawsuit reasons. So why do we have exclusions to this? Because if my contract is too broad, or what we call is an overbroad contract, meaning that it covers things in addition to the things it should cover. Here we're trying to protect confidential information, but if we don't have these exclusions, we're going to end up protecting information that is not confidential. And so this contract will be termed overbroad, and overbroad contracts are invalid. Why? Because they unnecessarily limit economic activities. We want, I mean, this is a free market society, right? So we want economic activity to be as free and open and flowing all over the place. And this is why we love contracts, because contracts allow for the economic activity to go forward, but we like our contracts to be extremely narrow so that we don't foreclose that economic activity to other people. And so here, if I'm putting all this burden on you to protect this information, but the information is not confidential, then my contract is producing burdens without benefits, and that creates that makes the contract be invalid. So we always put exclusions into contracts, things that on the first uh, brush you would think that they will be covered by the contract, but then you go ahead and you exclude them and you say, no, these are not covered by the contracts in order to protect its validity later on. So we have defined information. What should the receiving party do with this information? Duty of care. Use information only for the stated purpose and not use or exploit the information for their own exclusive benefit. So this is why in the beginning, when we defined what the stated purpose is, right, in slide 7, we said stated purpose is purpose of exploring the feasibility of potential business opportunities. Meaning what? Meaning that I cannot use this information to develop a product. If it comes out that the information was used to develop a product, then the information was not used for the stated purpose, and therefore the receiving party did not exercise its duty of care. Use at least the same level of care and protection of the information as they use to prevent the unauthorized use and unauthorized disclosure of the party's own confidential information. Meaning what? Again, meaning that when you receive my confidential information, that is now your confidential information, and you should treat it exactly the same way. And then hold in confidence and not disclose it unless you get our consent. And usually above, we also said that they need to disclose the information to defend themselves. Usually they ask and receive the consent of the other party when they identify exactly what information is going to be disclosed to defend themselves. Usually the other side will agree to that, because at the end you have to agree to it anyway. So these are kind of the main meat of an NDA. So it defines what an information is. It tells you what you're supposed to do with that information. It tells you what is not information. Now we go to boilerplates. I've only put in 3 of the boilerplates here. Of course, again, how they are worded, how many of these you have, what other areas they cover. It all has to do with the particular agreement you're putting in place. These 3 tend to be the most important ones, that basically every contract has these, because before the courts told us, guys, you need to put these into your contracts or life's going to be very difficult. Life was very difficult. So the first one is parallel evidence rule clause. What is parallel evidence? Parallel evidence means oral evidence. So you basically say, yeah, the contract said, I'm going to sell him this widget for $2. But afterwards we talked over the phone and I told him business is bad, so we decided on $2.50. He is not paying me the additional 50 cents. So the evidence of your oral conversation, evidence that is not in writing and is not part of the contract, once it enters the court as evidence, that is called parallel evidence. And the court is required to consider parallel evidence but decide what is the weight of that evidence. Maybe isn't going to give it any weight, maybe it's going to give it a lot of weight. That becomes the job of the judge and the jury to work that out. We don't want parallel evidence, right? We don't want people to come out of the woodwork and say, oh, yesterday you told my uncle that blah, blah. So none of that needs to be involved in a business deal. So we say this agreement sets forth the entire agreement and understanding between the parties and supersedes all prior oral and written agreements and understandings between them. The parties agree that this agreement may not be changed, modified, or released, discharged, abandoned, or otherwise terminated in whole or in part, except by agreement of the parties in writing. Meaning what? Meaning everything that we do has to be in writing. You want to end the agreement, that has to be in writing. You can just call me up and say, hey, I'm ending the agreement. You have to do it in writing. And everything we agree to is in this contract. So we kind of say it's the four corners of the contract are complete. There's no additional agreement between the parties outside of this. So this makes the introduction of parallel evidence inadmissible in the court. You can't talk about your phone conversation. Choice of laws clause. This is one of the favorite examples of courts and criminal law professors in law school, is that I'm standing in California, you're standing in Arizona, the border's between us, we're 10 feet apart, I take my gun out and I shoot and kill you. Whose criminal law applies to this? California's criminal law or Arizona's criminal law? Because I shot you from California, but you died in Arizona. So there's the choice of laws. Jurisprudence is extremely complex. We have many rules that determine the subject matter jurisdiction of the court, the personal jurisdiction over the parties, and whose law should apply. These are, I had a one semester course in law school about conflict of laws, and the end result of that was put a choice of laws clause in your contract because you don't want to go through that litigation. So it says this agreement is governed by the laws of California without regard to its long-arm statute and choice of law provisions. So long-arm statutes and choice of law provisions are provisions, statutory provisions in California law that gives jurisdiction over certain subject matters when those things happen outside of California. So this says don't look at those laws. They don't apply here. because we have all agreed that this is governed by the laws of California. The agreement shall be deemed to have made in California. Anything, so basically, last sentence. Oh, sorry. The parties acknowledge that venue for such actions shall lie exclusively in the county of San Diego, California. The parties hereby consent to both personal and subject matter jurisdiction for the courts of the county of San Diego, state of California, in adjudicating any dispute arising out of this agreement. So what is personal jurisdiction? Personal jurisdiction is that a court in California can only subpoena people who are in the state of California to appear in the court, unless you use those long arm statutes or choice of laws provisions. But according you can't be in Arizona and be summoned to a court in California. This is why when people are arrested, so you commit a crime in California and you fly to Illinois. In Illinois, you get arrested. You have to go through an extradition procedure that the court has to figure out whether jurisdiction over your person can be transferred from Illinois to California, and there are a ton of rules for that. And so here it says, we don't care about any of that. You can be in Australia, you can be in South Africa, but because you have agreed to this, you're subject to the personal jurisdiction of the court. Subject matter jurisdiction is whether the court is qualified to hear this kind of dispute. With state court actions, subject matter jurisdiction is normally not an issue because state courts have broad jurisdictions, but in federal courts, subject matter jurisdiction sometimes is a major issue that a case is won or lost. The last boilerplate I want to talk about is the severability clause. And that's because, again, under normal laws of contracts, as one of the clauses is found to be invalid, the entirety of the contract is invalid. In the severability clause, you say, no, the clauses are severable. So if one of them is held to be unenforceable, the remaining portions will remain enforceable. So if you screwed up in one area, that won't kill the whole deal. Okay, so what are the things we need to do if we work at a company, for a company? We run the company. The first thing is we have to enact and enforce reasonable measures to ensure the secrecy of our confidential information. What are they? We've talked about this a little bit. You have a reception area with a conference room and bathrooms that accessible to the public, but anything after that, you have to use your badge to go through the locked doors. Visitors can't go through it unless they sign in. And usually you guys have experience in this. When you sign in, you say who you're going to meet and for what reason. What is your name? What company you're coming from? You have to put all that in there so everybody knows what is going on, who visited and for what reason. You get a visitor's badge. That is not so that you know you're a visitor. It's so everybody else knows that you're a visitor. And as you approach, people stop talking. They turn their screens away from you. They turn their papers upside down, so you don't see. So you're basically immediately identifiable as somebody who should not be privy to the confidential information. And then all the NDAs with the outside people who do receive or potentially can receive your information. Other company actions, you have to have periodic refreshers on trade secrets. Most companies do it once a year. That seems to be enough. Make your NDAs standardized. And so basically what I do for my companies is basically you have an NDA that all they have to do is put in their name and put in the other guy's name and then sign it. That's it, because the effective date is the date as of the last signature, and all the other provisions are standard NDAs. And depending on who we're dealing with, we can throw our weight around all 2 pounds of it and say we won't negotiate any terms here, but some people do. And then remember I said, all documents need to be marked confidential. So what we do is we mark all documents marked confidential. It doesn't matter. So in Excel, Word, and PowerPoint, we basically have a standing macro that puts a watermark of confidential on all documents. And then when we go to finalize the document, we remove the watermark. That I found to be a pretty good practice. Well, this concludes what I wanted to talk about, and hopefully it was useful. And let's see if people have questions. Please come up, raise your hand, come up. Oh my God, there's a ton in the chat. I don't think I can read it all. Let me know if I need to. Hi, Plutos. Welcome to the stage.
Hey, how you doing? Okay, good. I wasn't sure if you were having problems. Yeah, it's working. Okay.
No, I can hear you. Yeah.
Okay. Yeah, I caught most of it. But I was gonna ask like a question. Like, see, you covered NDA parties, recitals, boilerplates, agreement terms. Oh my gosh, signatures. I'm mainly wondering, like, given the, the trends, the AI assisted contract review and like greater standardizations of NDAs, like how you think like legal practitioners should balance the standardization of the the need for all this like case specific language in each of these components, I guess.
So I don't see AI as having a major impact on this because when I write a contract, I don't start from scratch. I start with a similar contract I did in the past, and I use that as my template. And then change words around to make it specific to this situation, or remove clauses, add clauses. So really, it is not. It doesn't ever start out in a vacuum. It starts out by previous examples, and when you're first starting out, where does it come from? Well, previous examples of the partner you work for. You're right, but every time a case law comes up that says something, we go back and we change our template based on that. So I think what AI will do is what we've been doing all along, which is give you kind of the first draft template for your contract, and and then after that, you basically have to uh, individualize it for the specific uh, situation you're in.
Oh, okay. Yeah, yeah. I think I'm learning about. Yeah. So I think I'm clear. So how do you think companies should like adapt these, like these marketing requirements, right? Didn't you brought up confidentiality obligations written and marked. So like how should they, for AI generated content, like algorithmic outputs and like digital assets, right? Right. Like they may not have traditional document formats, right? Or
Sorry, I didn't quite catch what the question was. If you could
it's
repeat that.
like how should companies adapt these marketing requirements for AI generated content? Algorithmic outputs, I believe was another one, and digital assets that may not have traditional document formats. Because didn't you bring up oral, written, and confidentiality obligations marked within 30 days?
Yeah, so the thing is that the information that's generated, it doesn't matter who it's generated by, if it's generated by a machine or by a person. It is it's somewhere, right? In some format, it's in a database, and so the database is marked confidential. And so I think I don't think that uh, is an issue at all, because it is, you basically do with the information that's generated exactly as you do with the information generated by any of your employees or any of your computers. Uh, that part is the same. There are a lot of issues that arise with with AI and its use. This is not one of them.
Okay, then yeah. So besides that, yeah, you brought up, like yeah, reception areas, locked doors, signing procedures. Like we had some of that at Atari and other places. But like I said, we didn't have our conference room. Uh, we had a game room, but not at the front. But so besides that, like like what enhanced digital security measures should companies use, beyond your listed basics? Uh, Maybe is another question.
Yeah, well, that's your IT department and their anti-hacking uh, devices that they have, or procedures that they use. Yeah, so you basically have to have uh, reasonable firewalls on your servers uh, that people can't hack.
Oh yeah, yeah. Okay, so
So
That's,
so
that's,
if you put your information on Google Drive, right? That is not a violation of trade secrets because Google Drive is sufficiently hack-proof that putting it there is a reasonable is it's reasonable to assume your information there will be private, will be kept private.
oh, okay. And then yeah, let's see with the digital. Yeah, I don't think your presentation doesn't address remote work, right? Um,
Yeah, it does.
oh, but I thought yeah, regional measures. Yeah, so okay, so should they account for scattered like home offices and public
Yeah.
networks? Oh, okay, so
Well,
how
that's,
should
I mean,
the tradition? Oh,
this is how when you VPN into your work, you have to, you know, give in a whole bunch of passwords and go through a whole bunch of firewalls to be able to VPN in. So that's those are all the firewalls for anti-hacking as part of the reasonable efforts.
okay, yeah, I think okay, I think I'm getting this.
So let me put it this way. Reasonable efforts to maintain the secrecy, as we saw, doesn't create an additional onerous burden. It's reasonable efforts because those are the efforts that every company in that situation is employing. So we saw in DuPont v. Christopher, nobody's expected to put a roof under over a chemical plant that's being built. So putting a roof would have been unreasonable. Reasonable effort would have just been, you know, have a wall that nobody can look. Why? Because everybody else does it this way. So this is why we say reasonable efforts, because we assume that the majority of people are acting objectively and reasonably. So if the goal here is for you to take measures to protect the secrecy of the information because that information is important to you, not because you want to satisfy some prong of the trade secret law. The prong of the trade secret law will follow what it is that people in the marketplace are doing, and that's the word reasonable. That's the key.
Okay, yeah, okay, so and then not okay. So another point that I thought I saw was the duty of care obligations, like using information only for stated purposes. Uh, so like how should these duties be modified to just the AI assisted work, like where the boundaries between use, so you said use, disclosure, and analyses, like they become blurred, right? Like fuzzy logic, like
You
like
know,
how should
that is I can't give a broad uh, answer to that because really the stated purpose uh, has to do with the specific deal that the two companies are contemplating. And why is it that in this specific deal you want to disclose the information? So this is not a general thing, right? It always has to, well, why do you need my information and what are you going to do with it, right? That answer is not the same for everybody. Every deal is different. So I can't really uh, give a broad answer to that.
Oh, okay. Yeah, yes, yeah. Thanks a lot. I think I'm getting it, Sam.
Sure. Good. Anybody else? Any other questions? Io usually has a lot of experience with this stuff. Yeah, these are issues that for us, it's for startup company. Because if you go work for Pfizer or GM or any of the big ones, their NDAs, you know, all of this stuff pale in comparison with respect to what they do. And so what I'm talking about is really bare bones. You have to have these things. If you don't have these provisions that I put in this presentation, you don't have a valid NDA. But if you put all of these provisions, you don't have a complete NDA. Because there are a lot of other provisions that I didn't talk about that we put in there, and that again uh, depends on the specific purpose of the NDA, the stated purpose, and what the deal is going to be, and how things are evaluated, things like that. I have been an outside party to several deals in the sense that at the beginning, let's say I have I'm a chemical or a pharmaceutical company, and I have all of these drugs that I've synthesized, and you have made one compound, and you want to see if I have made derivatives of your compound so you can buy those from me, or if based on the core structure that you identified, you think that my compounds will work for in your system. But I don't want to tell you what my system is, and you don't want to tell me what your compounds are. So you hire somebody like me, who knows chemistry and knows the law, and this guy gives me his compounds, and that guy gives me the details of the system, and I look, and I either say, no, you guys are barking up the wrong tree, or I say, yes, this is something that you guys could find common ground on. And then once I decide that, then they go ahead and sign NDAs and then exchange information. And usually in that situation, not only do I not represent either party, but I I don't have the remotest connection to either party, so that there's absolutely no question of conflict of interest at all. So that's another way that people decide whether they want to share their confidential information before they actually share.
Right. So how would you like analyze like a hypothetical like a scenario like where an AI system trained on publicly available data, right? Is that right? Or wait, am I missing something? produce and produces some things that mirror competitors, proprietary, like an algorithm. Like, can you like analyze a hypothetical situation like that, maybe?
So no, but I'm going to tell you what the law says so far. And the law says just because all the components of the information are in the public domain doesn't mean that the information is not confidential, because the the value of it, the secret of it, is how they are combined, not whether they are combined. And so, and we're going to see that uh, later on in a few weeks when we talk about uh, obviousness in patenting, is that uh, deciding what the problem is and how it should be fixed is part of the invention, even though once you determine how it should be fixed, the solution is very obvious to anyone. So basically, the specific combination of the information itself can be very valuable information, even though all the components are in the public domain. So now, if AI is doing this, the question is, uh, what is AI doing with the public domain? How is it evaluating? What is the uh, weight value that the AI is giving to each particular information, and why? You know, then what is the algorithm of the AI for summarizing this? So all of those then would become your trade secret, not just the fact that uh, we we have gathered stuff from the public domain.
Okay, then maybe another one is, I think you have a PhD in chemistry. Like, so how should like different, like trade secret protection strategies, differ, like across like industries, like pharmaceuticals, with with regulatory data protection, you know, right, concerns, and like technology, yeah, and then and manufacturing, maybe like with the today's climate, global supply chains.
Uh,
So different, uh like trade secret, strategies. Like, I'm just wondering how they may differ from those three examples: tech and big pharma, manufacturing with the global aspect. I don't know how the strategies would work.
yeah, so you end up with NDAs that are 50 pages long because the deal is so complex that you really can't have one provision fits all. So for, you know, such and such set of data, you have this set of requirements. For the other set of data, you have that set of requirements. For financial data, you have this set of requirements. It's as I said, all of these agreements outside of what it was that I told you in this presentation, outside of that, any other provision is just specific to that deal. And I can't I mean, speak kind of generally, like, how do pharma companies do it differently than tech companies? Well, I can tell you, I can, you can even ask how does Pfizer do it differently than Merck? Or you can say, how does, Joe's Pharmaceuticals does it differently than Bob's Pharmaceuticals? And you can say, how does Joe's Pharmaceuticals does it differently when it's dealing with the Bob supplier or with Ben's supplier, right? All of those could be completely different NDAs because the subject matter of the deal is completely different. So really, once you get outside of this is information, da da da, then you really have to make it uh, be specific to the deal, and that's so far AI hasn't been able to do what an attorney does with respect to understanding the deal, understanding the requirements of the deal, understanding the requirements of your CEO, and then deciding the scope of the NDA based on all of those. So there's a lot that goes into it. That's not just spitting out a document. Melanie, I've sent you an invite. I don't know if you have gotten that, but anytime you want. If
Oh,
not,
sorry. I had
uh,
navigated to the screen. I was just
okay.
listening in to, the conversation. And I'm not sure if you just focused today in conversation on trade secret law, but certainly I think some of the intellectual property discourse that is happening, does cover, um, copyrights and trademarks, etc. Or is it not? First, that's my first question.
Yeah, so we just finished our trade secret talk. We had it took 6 weeks to do trade secrets. And next week we're gonna start on patents. After patents, we go to copyrights, and then we'll finish it with trademarks. So we have only discussed trade secrets so far.
Okay, got you. Well, then, what I was going to speak to, just in terms of some of the questions that, is it Plutos? Am I saying that right? Plutos? Anyway,
Yeah,
yes.
or Kevin. Kevin's my real name.
Oh,
Yeah,
hey, Kevin.
that's our AI startup. Yeah.
Got you. Well, hello. Yeah, just in terms of, relating to AI, because, several cases exist currently, which I'm sure you are aware, as far as um, copyright infringement, and that being used to develop a lot of the LLMs, which are the large language models, to develop their technology for AI. Strangely, like most of these cases are in progress. So some of them, may change things, certainly with case law going forward. But like, for instance, one of them is I guess what would be the first class action suit against well, actually it's a number of companies named in that one. So I thought, we were kind of speaking about these things, but if copyright is later on, then maybe I'll join it at that time. But it's certainly an area of increased interest for a variety of industries, uh, because of the way that AI uses not only, say, content, as far as from newspapers. There have been cases for that, music, art, you name it, to generate things for people or provide them. I guess it's all generation, to be honest with you. But how they actually even refer to quotes, like I think it was the New York Times and somebody else that they incorrectly quoted them or attributed certain things to them, and also, um, well, I guess those two different things. They quoted them incorrectly, so misquoted them, and then attributed things to them that they never said, in other articles. So I mean, there have been a number of cases, but certainly this is a huge area, I think right now of interest, certainly in the legal sense. You were just talking about the attorneys, and even on this app, different people have come to the app with ideas early on, say like when Clubhouse first started, for to create AI judges and all sorts of interesting things. I agree with you. I don't think we're quite there yet, but it's definitely something that people are trying to do going forward. So yeah, I'll tune back in for the portion of your coverage on these topics.
Very good. Thanks. Um, uh, just just to very kind of we're not discussing this, and we're not into details at all, but uh, false attribution is not a copyright violation because you haven't copied anything.
Right. I didn't say that.
Yeah, yeah,
Name that as one of the cases that are out there, but there
right,
are a number of them that are specifically copyright infringements, particularly in the music areas.
right. No, false attribution could be a trademark violation, uh, but then uh, or it's just a tort of false attribution on itself. No, we'll discuss these in both copyrights and trademark section, which come up after the patents. Patents should take a while because trade secrets here took 6 sessions, and in my law school class it's 2 classes. Patents take about 8. So we're in for a long haul on the patent side. But people in general, uh, people can relate to patents uh, a lot more because it deals with the competition in the market and how do you stop the competition in the market. Trade secrets is interesting, or from a pedagogical point of view, because it kind of gets the students' minds uh, comfortable with the idea of the ownership of information. That's really easy to wrap your head around ownership of information, uh, and protection of the information, and you don't want everybody to use your information, things like that. And so once we're comfortable with that, we can now go ahead and talk about patents, which is really uh, the 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 800-pound gorilla of protections. Yeah, so Austin, yeah, you're still here. As kind of, I've seen a whole bunch of uh, your comments about international IP and whether people or countries or G7 is part of any agreement. There are 2 main agreements. One is the Patent Cooperation Treaty Agreement, or the PCT, and the other one is the General Agreement on Tariffs and Trade, Uruguay round. GATT was 1995, went into effect June of 96. Patent Cooperation Treaty went into effect, I believe, 1975. And most countries in the world, actually, I think of North Korea as the only one for now, but there are probably other ones, are signatories to those treaties. And so the Patent Cooperation Treaty allows for countries to file a single international application and then prosecute that application in whatever jurisdiction they choose. And then it also sets basically PCT has its own laws for examination of patents. Many smaller countries have just wholesale adopted the PCT rules. And the PCT rules are based on European laws, and European laws are in part based on US laws. So even though these are all different sources of laws, they basically all say the same thing at the end of the day. And so yes, there is a lot of agreement between laws of different countries. Some are, more strict than others. So for example, we all have what's called the written description requirement. That is, the invention has to be written up in sufficient clarity. And then, well, part of that written description is reduction to practice. Do you have to have reduced invention to practice before you can describe it, or can you prophetically describe the invention? And so the US says you can prophetically describe the invention. China says no, you have to have reduced to practice, but they both require the written description to be there. Are there any other questions or comments, or should we bid everyone farewell? Okay, so I guess we're done. Shamash, any updates for you, or you're still on
Still on
radio
break.
silence? Okay.
Not radio silence. I'm here, but I'm not preparing my rooms.
Okay.
Yeah, I need the time to focus on other projects. So yeah, still on break. People can catch you on Thursday for the chemistry series. You want to say something about that?
Yes. So we're gonna do the chemistry class on Thursday. I'm gonna talk about chirality.
We already did chirality in the past.
Yeah, well, that was many years ago. I'm repeating it so that we can then talk about the structure of carbocations and what's a psi phase, what's a ray phase, and all that.
Cool.
So yeah.
And that would be at what time?
So
I think for me
Thursday
it's 10 p.m. here. So it's 2 p.m. Eastern.
2 Mountain Time, 4 Eastern, 1 Pacific.
Fantastic.
So
And
4 Eastern. Yeah,
they can catch John as well on Friday for his Bites of Physics.
Yes, I think he's going to have one this week. So very good. All right, everyone. I had technical difficulties with my system, so
You want to
I'm
play?
not going
You
to.
want me to play the room
Yeah,
out?
yeah. If you
Okay.
can do that,
Give,
that'd be great.
give me 30 seconds.
All right. So I hope everybody has a great rest of the day and a great Wednesday, and hope to see you Thursday in the chemistry class and other places in Clubhouse.